Question 1. Topic: HIPAA. Privacy and security rules in high-stakes environment where multiple challenges arise due to the increasing use of telemedicine. Large healthcare system implements new telehealth platform to facilitate virtual patient consultations. However, an audit later reveals that the system failed to secure protected health information by adequately exposing patient data to unauthorized third parties. Under HIPAA, which of the following is the most legally significant consequence the healthcare system could face? A. Criminal prosecution of the physicians who used the system for patient consultations. B. Civil penalties imposed by the Office for Civil Rights (OCR) due to non-compliance with HIPAA security rule requirements. C. Lawsuit filed by patients under HIPAA's private right of action. D. Automatic termination of the healthcare system's Medicare and Medicaid reimbursements. Answer: B. Civil penalties imposed by the Office for Civil Rights (OR) due to non-compliance with HIPAA security rule requirements. Explanation: under HIPAA, Health Insurance Portability and Accountability Act, healthcare entities must comply with strict privacy and security rules to protect patients' FI. The security rule mandates administrative, physical, and technical safeguards to ensure FI is protected against unauthorized access. To implement adequate security controls, such as encryption or access restrictions, constitutes a violation of HIPAA. A. Incorrect. HIPAA violations do not automatically result in criminal charges against physicians unless there is intentional misconduct, such as knowingly disclosing FI for personal gain. B. Correct. The Department of Health and Human Service (HHS) Office for Civil Rights (OSR) enforces HIPAA violations and can impose civil penalties ranging from $100 to $50,000 per violation, with a maximum annual penalty of $1.5 million. C. Incorrect. HIPAA does not provide a private right of action, meaning patients cannot directly sue healthcare providers for violations. Instead, they can file complaints with OR. D. Incorrect. While severe HIPAA violations might lead to exclusion from Medicare and Medicaid, it is not an automatic consequence. The Centers for Medicare and Medicaid Services (CMS) evaluates each case individually. Question tests candidates on HIPAA enforcement mechanisms and patient rights, which are crucial for legal compliance in healthcare. Question 2. Topic: Medical malpractice. Standard of care and informed consent. During comprehensive review of process that needs improvement, hospital's legal team evaluates the circumstances of malpractice claim. The case involves surgeon who performed an innovative procedure without informing the patient of its experimental nature. The patient experienced severe complications and sued for medical malpractice. Which legal principle is relevant in determining liability in this case? A. Res ipsa loquitur. B. Standard of care deviation. C. Contributory negligence. D. The False Claims Act. Answer: B. Standard of care deviation. Explanation: medical malpractice occurs when a healthcare provider breaches the standard of care, leading to patient harm. In this case, failing to disclose the experimental nature of the procedure violates the doctrine of informed consent, which is a core principle in medical law. A. Incorrect. Res ipsa loquitur. The thing speaks for itself applies when negligence is presumed because the injury could not have occurred without it, such as leaving a surgical instrument inside a patient. Here, the issue is lack of informed consent, not an obviously negligent act. B. Correct. The standard of care requires physicians to inform patients of material risks, benefits, and alternatives before obtaining consent. Failure to do so constitute negligence. C. Incorrect. Contributory negligence refers to cases where the patient's actions contributed to their own injury, which is not applicable here since the patient was unaware of the experimental nature of the procedure. D. Incorrect. The False Claims Act addresses fraudulent billing practices, such as submitting false Medicare claims, which is unrelated to this case. This question assesses students' understanding of informed consent, standard of care, both of which are critical in malpractice litigation. Question 3. Topic: EMTALA. Emergency treatment requirements during an emergency response where multiple areas are impacted. Hospital in rural town is overwhelmed with patients following natural disaster. Critically injured patient arrives at the emergency department, but the hospital, citing resource limitations, refuses to provide an initial medical screening and instead directs the patient to another facility 30 miles away. Under the Emergency Medical Treatment and Active Labor Act (EMTALA), which legal consequence is the most likely for this hospital? A. The hospital could face substantial fines and exclusion from Medicare participation. B. The hospital could be forced to provide treatment to every patient free of charge. C. The hospital's physicians could be individually sued for damages by the patient. D. The hospital is immune from liability because of the disaster's exceptional circumstances. And so A. The hospital could face substantial fines and exclusion from Medicare participation. Explanation. EMTALA, Emergency Medical Treatment and Active Labor Act, requires hospitals with emergency departments to provide a medical screening examination to anyone seeking treatment, regardless of their ability to pay. If a patient has an emergency medical condition, the hospital must stabilize them before transferring them to another facility unless an appropriate transfer is necessary. A. Correct. Violating EMTALA can result in fines of up to $119,942 per violation, adjusted for inflation, and potential exclusion from Medicare, which is a critical source of hospital funding. B. Incorrect. EMTALA does not require hospitals to provide free treatment to all patients, only an emergency screening and stabilization for those with emergency conditions. C. Incorrect. Enforcement is handled by the Centers for Medicare and Medicaid Services (CMS) and the Office of Inspector General (OIG). While patients can file complaints, the law does not provide an independent right for them to sue physicians for damages. D. Incorrect. EMTALA applies even in disaster scenarios unless the hospital is officially designated as a non-operational facility through federal or state emergency declarations. This question, students understand emergency care obligations, an essential topic in health law exams. Question 4. During a comprehensive review of a process that needs improvement, a hospital compliance officer discovers that several physicians are referring Medicare patients to an imaging center owned by their family members. Upon further investigation, it is found that these referrals have led to substantial financial benefits for the physician's relatives. Given the applicable federal regulations, what is the most appropriate legal concern regarding these actions? A. The False Claims Act (FCA) violation for submitting fraudulent claims to Medicare. B. The Stark Law violation for improper physician self-referral. C. The Anti-Kickback Statute Act's violation for financial incentives in referrals. D. The Emergency Medical Treatment and Active Labor Act (EMTALA) violation for improper patient transfers. Answer. B. The Stark Law violation for improper physician self-referral. Explanation. The Stark Law, physician self-referral law, prohibits physicians from referring Medicare and Medicaid patients to entities in which they or their immediate family members have a financial interest, unless an exception applies. In this case, the physicians are referring patients to an imaging center owned by their family members, which is a direct violation. The Stark Law is a liability statute, meaning intent does not have to be proven. If the financial relationship exists and referral is made, the law is violated. Why not? False Claims Act. The FCA penalizes the submission of fraudulent claims for government reimbursement. While Stark Law violation can lead to FCA liability, FCA requires proof of knowingly submitting false claims, which is not the primary issue here. Why not? C. Anti-Kickback Statute. The Act applies when there is an intent to offer or receive remuneration in exchange for referrals. Stark Law violations do not require intent, making it the more relevant law here. Why not? D. EMTALA. EMTALA governs emergency treatment requirements and patient stabilization before transfers, which is unrelated to self-referrals in Medicare billing. Question 5. When implementing new protocols in a shared environment, a large healthcare system decides to introduce an AI-powered diagnostic tool to assist physicians in making treatment decisions. The tool collects and analyzes patient data, offering recommendations for care based on predictive analytics. However, concerns arise regarding the tool's decision-making process, particularly how patient data is stored, accessed, and used. Which following laws is most relevant in addressing these concerns? A. The Health Insurance Portability and Accountability Act, HIPAA, Privacy and Security Rules. B. The Sherman Act, which prohibits monopolistic practices in healthcare. C. The False Claims Act, FCA, which addresses fraudulent billing practices. D. The Emergency Medical Treatment and Active Labor Act, EMTALA. Answer A. The Health Insurance Portability and Accountability Act, HIPAA, Privacy and Security Rules. Explanation. HIPAA's privacy rule and security rule are directly relevant when dealing with AI tools that collect and analyze patient data. The privacy rule governs how protected health information (FI) can be used and disclosed, while the security rule requires safeguards to protect electronic FI from breaches or unauthorized access. AI-powered diagnostic tools that handle patient data must comply with these rules to prevent privacy violations and unauthorized access to sensitive medical information. Why not? B. Sherman Act. The Sherman Act prohibits anti-competitive practices in healthcare, such as monopolistic mergers and price fixing. While AI in healthcare raises concerns about competition, the immediate issue here is data privacy, not monopolistic behavior. Why not C. False Claims Act? The FCA addresses fraudulent claims for government healthcare programs. While AI errors could potentially lead to false claims, the primary issue in this scenario is data privacy, not fraudulent billing. Why not D. EMTALA? EMTALA ensures emergency care is provided regardless of patients' ability to pay. It does not regulate AI-based decision-making or data privacy. Question 6. In a situation where formal requirements conflict with patient autonomy, a terminally ill patient expresses a wish to refuse life-sustaining treatment, including mechanical ventilation. However, the patient's family members strongly disagree and demand that all possible measures be taken to keep the patient alive. The hospital's ethics committee is consulted to determine the legal and ethical basis for the decision. Which of the following legal principles supports honoring the patient's wishes? A. The principle of beneficence, which requires physicians to act in the best interest of the patient. B. The principle of autonomy, which upholds the patient's right to make healthcare decisions. C. The principle of non-maleficence, which prevents harm to the patient by avoiding unnecessary treatment. D. The principle of justice, which ensures fair distribution of healthcare resources. Answer. B. The principle of autonomy, which upholds the patient's right to make healthcare decisions. Explanation. The principle of autonomy is fundamental ethical and legal doctrine in healthcare that allows patients to make their own medical decisions, including the right to refuse treatment. This right is protected under the Due Process Clause of the 14th Amendment and reinforced by the Patient Self-Determination Act (PSDA), which requires health providers to inform patients of their right to accept or refuse medical treatment. Why not beneficence? Beneficence requires physicians to act in the best interest of the patient, but this does not override competent patients' right to refuse treatment. Why not C. Non-maleficence? Non-maleficence requires avoiding harm, but forcing unwanted treatment on patient can be considered harm rather than protection. Why not D. Justice? Justice relates to the fair allocation of healthcare resources. While it plays a role in healthcare decisions, it does not directly address individual patient autonomy in refusing treatment. Question 7. During a major transformation where existing methods must adapt to new policies, a hospital implements a new policy requiring all employees to receive annual flu vaccinations unless they have a documented medical or religious exemption. A group of employees objects, arguing that the mandate violates their rights. Under which legal framework would the court evaluate the validity of the hospital's policy? A. The Occupational Safety and Health Act (OSHA). B. Title IX of the Civil Rights Act of 1964. C. The Health Insurance Portability and Accountability Act (HIPAA). D. The Emergency Medical Treatment and Active Labor Act (EMTALA). Answer. B. Title Roman of the Civil Rights Act of 1964. Explanation. Title Roman prohibits discrimination based on religion and requires employers to provide reasonable accommodations for employees' religious beliefs, unless doing so would impose an undue hardship on the employer. Courts evaluating flu vaccine mandates often consider whether the employer made reasonable accommodations, e.g., allowing mask wearing instead of vaccine, and whether the refusal poses significant risk to patient safety. Why not OSHA? OSHA regulates workplace safety but does not specifically govern vaccine mandates or religious exemptions. Why not C. HIPAA? HIPAA governs patient privacy but does not apply to employer-mandated vaccinations. Why not D. EMTALA? EMTALA mandates emergency care but does not regulate employment policies related to vaccinations. Question 8. During a major transformation where existing methods must adapt to new policies, a hospital system decides to transition all patient records to a cloud-based electronic health record system. However, soon after implementation, a cyber attack occurs, exposing thousands of patient records. The hospital is now facing an investigation regarding potential violations of federal regulations. Which law is most relevant to compliance in this situation? A. The Health Insurance Portability and Accountability Act (HIPAA). B. The False Claims Act (FCA). C. The Emergency Medical Treatment and Active Labor Act (EMTALA). D. The Stark Law. Answer A. The Health Insurance Portability and Accountability Act (HIPAA). Explanation. HIPAA's security rule mandates safeguards to ensure the confidentiality, integrity, and availability of electronic protected health information (FI). Organizations that transition to cloud-based AI systems must implement administrative, physical, and technical safeguards to prevent breaches. If cyber attack exposes patient records, the hospital must comply with HIPAA's breach notification rule, which requires notification to affected patients, the Department of Health and Human Service (HHS), and sometimes the media. Why not B. False Claims Act? The FCA targets fraudulent billing to government programs like Medicare and Medicaid, but it does not directly regulate data security breaches. Why not C. EMTALA? EMTALA ensures emergency patient care but does not address data security or patient privacy. Why not D. Stark Law? The Stark Law prohibits physician self-referrals, which is unrelated to data security. Question 9. When implementing new protocols in a shared environment, a multi-specialty medical group decides to integrate telemedicine into its practice, allowing doctors to consult patients across state lines. However, some physicians are unsure about the legal implications of providing care to patients outside their licensed jurisdiction. What is the most significant legal concern they must address? A. Compliance with state medical licensure laws. B. HIPAA's privacy and security rules. C. The False Claims Act (FCA). D. The Stark Law. Answer A. Compliance with state medical licensure laws. Explanation. State medical boards regulate physician licensure, meaning a doctor must be licensed in the state where the patient is physically located at the time of a consultation. The Interstate Medical Licensure Compact (IMLCI) allows expedited licensing in multiple states, but not all states participate. If a doctor practices telemedicine across state lines without proper licensure, they risk disciplinary action, fines, and potential criminal charges. Why not B. HIPAA? While HIPAA is crucial in telemedicine, the primary issue here is legal authorization to practice in another state. Why not C. FCA? FCA concerns fraudulent billing, which is separate from licensure requirements. Why not D. Stark Law? The Stark Law deals with physician self-referrals, which is unrelated to telemedicine licensing. Question 10. During a comprehensive review of a process that needs improvement, a health insurance company discovers that one of its contracted hospitals has been routinely billing Medicare for inpatient stays when the patients should have been classified as outpatients under the Two-Midnight Rule. What potential violation has the hospital committed? A. A violation of the False Claims Act (FCA). B. A violation of HIPAA's privacy rule. C. Violation of the Stark Law. D. Violation of the Emergency Medical Treatment and Active Labor Act (EMTALA). Answer A. A violation of the False Claims Act (FCA). Explanation. The False Claims Act (FCA) prohibits knowingly submitting false or fraudulent claims to the federal government. Under Medicare's Two-Midnight Rule, inpatient hospital stays are only reimbursed if the admitting physician reasonably expects the patient to need hospital care for at least 2 midnights. If hospital deliberately classifies short stays as inpatient admissions to receive higher reimbursements, it could be liable under the FCA. Why not B. HIPAA? HIPAA regulates patient privacy, not improper billing. Why not C. Stark Law? The Stark Law applies to physician self-referrals, not fraudulent billing. Why not D. EMTALA? EMTALA requires emergency stabilization and treatment but does not govern billing classifications. Question 11. In a situation where formal requirements conflict with patient autonomy, a hospital is treating a pregnant patient whose fetus has a fatal abnormality incompatible with life outside the womb. The patient requests to terminate the pregnancy, but the hospital is in a state that has enacted strict abortion bans. What federal law might override state restrictions in this case? A. The Emergency Medical Treatment and Active Labor Act (EMTALA). B. The Health Insurance Portability and Accountability Act (HIPAA). C. The Stark Law. D. The False Claims Act (FCA). Answer A. The Emergency Medical Treatment and Active Labor Act (EMTALA). Explanation. EMTALA requires hospitals to provide emergency medical care regardless of state laws. If a patient presents with a medical emergency, including pregnancy complication that threatens her health, the hospital must provide stabilizing treatment, even if that treatment includes an abortion. The federal mandate of EMTALA can override state abortion bans. Emergency care is necessary. Why not B. HIPAA? HIPAA governs patient privacy but does not regulate emergency medical treatment. Why not C. Stark Law? The Stark Law applies to physician self-referrals, not emergency treatment. Why not D. FCA? The FCA deals with fraudulent claims, not emergency medical obligations. Question 12. During a major transformation where existing methods must adapt to new policies, a pharmaceutical company launches a new marketing strategy offering free consulting services to physicians who frequently prescribe its medications. Competitors argue that this could be a violation of federal law. What legal risk does the company face? A. A violation of the Anti-Kickback Statute Acts. B. A violation of the False Claims Act FCA. C. A violation of HIPAA. D. A violation of EMTALA. Answer A. A violation of the Anti-Kickback Statute Acts. Explanation. The Anti-Kickback Statute Acts prohibits offering, paying, soliciting, or receiving anything of value in exchange for patient referrals or business involving federal healthcare programs. If a pharmaceutical company offers free consulting services to incentivize prescriptions, this could be seen as an illegal inducement violating the Acts. Why not B. FCA? The FCA concerns fraudulent claims, while Act specifically addresses improper financial incentives. Why not C. HIPAA? HIPAA regulates patient privacy, not marketing practices. Why not D. EMTALA? EMTALA ensures emergency treatment but does not govern pharmaceutical marketing. Question 13. During a critical moment when precise judgment is necessary, a hospital's emergency department is overwhelmed due to natural disaster. Medical staff must prioritize which patients receive immediate care based on severity. However, some patients with non-life-threatening conditions complain that they will refuse treatment. What legal principle protects hospitals in such situations? A. The Emergency Medical Treatment and Active Labor Act EMTALA. B. The Good Samaritan Law. C. The Public Readiness and Emergency Preparedness PrEP Act. D. The False Claims Act FCA. Answer A. The Emergency Medical Treatment and Active Labor Act EMTALA. Explanation. EMTALA requires hospitals to provide a medical screening examination, MSc, and stabilization for anyone arriving at the emergency department regardless of ability to pay. However, in a disaster scenario, hospitals can implement crisis standards of care under federal emergency declarations, allowing them to triage patients based on severity. If the hospital follows approved triage protocols without discrimination, they are protected from liability under EMTALA and state emergency laws. Why not B. Good Samaritan Law? This law protects individuals, not hospitals, from liability when providing emergency aid. Why not C. PrEP Act? The PrEP Act applies to medical countermeasures, e.g. vaccines in public health emergencies. Why not D. FCA? The FCA concerns fraudulent claims but does not govern emergency care. Question 14. When implementing new protocols in a shared environment, a major healthcare system adopts artificial intelligence (AI) to analyze radiology scans. However, after 6 months, an audit reveals that the AI algorithm disproportionately misdiagnoses patients of certain ethnic backgrounds. Well, federal law might apply in this situation. A. Till Romans, the Civil Rights Act. B. The Health Insurance Portability and Accountability Act, HIPAA. C. The Stark Law. D. The False Claims Act, FCA. Answer A. Till Romans, the Civil Rights Act. Explanation. Till Roman era hits discrimination based on race, color, or national origin in any program receiving federal funds, including hospitals and healthcare providers. If an AI system systematically misdiagnoses patients of certain ethnicities, it could be a violation of civil rights law. The healthcare system must take corrective action or risk losing federal funding and facing penalties. Why not B. HIPAA? HIPAA concerns data privacy, not discrimination. Why not C. Stark Law? The Stark Law governs physician self-referrals, which is unrelated here. Why not D. FCA? The FCA involves fraudulent billing, no AI bias. Question 15. In a situation where formal requirements conflict with patient autonomy, a terminally ill patient requests physician-assisted dying in a state where the practice is illegal. The physician wants to honor the patient's wishes but is concerned about legal consequences. What legal framework should the physician consider? A. State medical licensing laws and right to die statutes. B. The Health Insurance Portability and Accountability Act, HIPAA. C. The Emergency Medical Treatment and Active Labor Act, EMTALA. D. The Anti-Kickback Statute Act. Answer A. State medical licensing laws and right to die statutes. Explanation. Physician-assisted dying is legal only in certain states, e.g. Oregon's Death with Dignity Act. If the practice is illegal in the physician's state, they could face criminal charges, license revocation, and civil lawsuits. However, states that permit physician-assisted dying require strict eligibility criteria such as terminal illness and mental capacity assessments. Why not B. HIPAA? HIPAA governs patient privacy, not assisted dying. Why not C. EMTALA? EMTALA mandates emergency care, which is unrelated to physician-assisted dying. Why not D. ACTS? The ACTS concerns improper financial incentives, not end-of-life care. Question 16. During a major transformation where existing methods must adapt to new policies, a health insurance company starts using AI-driven algorithms to approve or deny medical claims. However, multiple complaints arise that the system unfairly denies claims for expensive treatments even when medically necessary. What legal risk does the company face? A. A violation of the Affordable Care Act (ACA) protections. B. A violation of the False Claims Act (FCA). C. A violation of the Health Insurance Portability and Accountability Act (HIPAA). D. A violation of the Emergency Medical Treatment and Active Labor Act (EMTALA). Answer A. A violation of the Affordable Care Act (ACA) protections. Explanation. The ACA prohibits insurers from denying medically necessary treatments based on arbitrary policies. If the AI system unfairly denies claims, the insurer could face federal fines, lawsuits, and regulatory penalties. Patients may also have grounds to appeal denials under ACA's internal and external review rights. Why not B. FCA? The FCA applies to fraudulent claims submitted to the government, not claim denials by insurers. Why not C. HIPAA? HIPAA deals with data privacy, not insurance claim denials. Why not D. EMTALA? EMTALA requires emergency care but does not regulate insurance claims. Question 17. When implementing new protocols in a shared environment, a hospital begins requiring genetic testing for all new employees to assess workplace health risks. Several employees feel this is an invasion of privacy and raise legal concerns. What federal law might protect them? A. The Genetic Information Non-Discrimination Act (GINA). B. The Americans with Disabilities Act (ADA). C. A Health Insurance Portability and Accountability Act (HIPAA). D. The Stark Law. Answer A. The Genetic Information Non-Discrimination Act (GINA). Explanation. GINA prohibits employers from using genetic information to make hiring, firing, or insurance decisions. If the hospital mandates genetic testing, it could face lawsuits for discrimination. Why not B. ADA? The ADA protects people with disabilities but does not specifically address genetic discrimination. Why not C. HIPAA? HIPAA protects health records, but GINA directly governs genetic discrimination. Why not D. Stark Law? The Stark Law deals with physician self-referrals, not employment policies. Question 18. During a critical moment when precise judgment is necessary, a nurse discovers a medication dosage error in a patient's electronic health record error. The error was due to an autofill function that defaulted to higher dosage. The nurse administers the correct dosage, but the hospital administration debates whether the issue should be reported. What law might require reporting of such errors? A. The Patient Safety and Quality Improvement Act (PSCIA). B. The False Claims Act (FCA). C. The Stark Law. D. The Public Readiness and Emergency Preparedness (PrEP) Act. Answer A. The Patient Safety and Quality Improvement Act (PSCIA). Explanation. PSCIA encourages healthcare providers to report medical errors without fear of retaliation. The law protects reports submitted to patient safety organizations so as to improve care quality. Why not B. FCA? The FCA targets fraudulent billing, not medical errors. Why not C. Stark Law? The Stark Law deals with physician referrals. Why not D. PrEP Act? The PrEP Act covers public health emergencies, not routine medical errors. Question 19. During a critical moment when precise judgment is necessary, a surgeon encounters an unexpected complication during a routine procedure. To prevent further harm, the surgeon deviates from the standard protocol. Later, a malpractice claim is filed. What legal doctrine might protect the surgeon? A. The doctrine of res ipsa loquitur. B. The doctrine of informed consent. C. The doctrine of good faith. D. The doctrine of emergency necessity. Answer D. The doctrine of emergency necessity. Explanation. The doctrine of emergency necessity provides legal protection for physicians who must make split-second decisions in life-threatening situations. If a physician reasonably deviates from standard procedures to prevent harm, the court may recognize this as a justifiable action provided there was no negligence or recklessness. Why not res ipsa loquitur? This doctrine applies when negligence is presumed based on the nature of an injury. Why not be informed consent? This doctrine requires patient agreement to procedures but does not cover emergency deviations. Why not C. Good faith? While acting in good faith is essential, it does not provide legal immunity in medical negligence cases. Question 20. When implementing new protocols in a shared environment, a financial institution adopts an AI-powered system to analyze customer transactions for fraud detection. However, regulators discover that AI disproportionately flags accounts based on ethnic names. What legal risk does the institution face? A. A violation of the Fair Credit Reporting Act (FCRA). B. A violation of the Equal Credit Opportunity Act (ECOA). C. A violation of the Gramm-Leach-Bliley Act (GBA). D. A violation of the Sarbanes-Oxley Act (SOX). Answer: B. A violation of the Equal Credit Opportunity Act (ECO). Explanation: ECO prohibits discrimination in credit decisions based on race, religion, gender, or ethnicity. If AI disproportionately flags certain ethnic groups, it may constitute algorithmic bias, leading to regulatory fines, lawsuits, and reputational damage. Why no FCRA? If CRI governs credit reporting agencies, no AI-driven fraud detection. Why not E? GBEBA concerns financial data privacy, not discrimination. Why not D? SOX? SOX deals with corporate financial reporting compliance, not bias in fraud detection. Question 21. In a situation where formal requirements conflict with patient autonomy, a psychiatric hospital implements mandatory treatment policies for patients with severe mental illnesses. However, a patient refuses treatment, claiming a right to personal autonomy. What legal framework applies? A. The Americans with Disabilities Act (ADA). B. The Mental Health Parity and Addiction Equity Act (MHPA). C. The Patient Self-Determination Act (PCDA). D. The Emergency Medical Treatment and Active Labor Act (EMTALA). Answer: C. The Patient Self-Determination Act (PCDA). Explanation: the PCDA ensures that patients have the right to refuse medical treatment even if they are mentally ill, unless the court has deemed them legally incompetent. Hospitals must balance patient autonomy with duty of care under legal guardianship and psychiatric hold laws. Why now ADA? The ADA protects against discrimination but does not govern treatment refusal. Why not B? MHPA? MHPA ensures insurance parity for mental health, not patient rights. Why not D? EMTALA? EMTALA ensures emergency treatment, but does not address long-term psychiatric care. Question 22. During a major transformation where existing methods must adapt to new policies, a pharmaceutical company uses real-world patient data to improve drug formulations. However, privacy advocates claim the company failed to obtain proper patient consent before using the data. What law applies? A. The Health Insurance Portability and Accountability Act (HIPAA). B. The Genetic Information Non-Discrimination Act (GINA). C. The Food, Drug and Cosmetic Act (FDA). D. The False Claims Act (SEA). Answer: A. The Health Insurance Portability and Accountability Act (HIPAA). Explanation: HIPAA requires patient consent before using identifiable health data for research. Pharmaceutical companies must comply with HIPAA when using patient records or risk federal penalties and lawsuits. Why not B? GINA? GINA covers genetic data, not general patient records. Why not C? FDA? FDA governs drug safety, not patient privacy. Why not D? FCA applies to fraudulent billing, not data privacy. Question 23. When implementing new protocols in a shared environment, a corporation requires employees to disclose personal financial records before being considered for promotions. Some employees claim this violates privacy laws. Which law applies? A. The Fair Credit Reporting Act (FCRA). B. The Family and Medical Leave Act (FLA). C. The Sarbanes-Oxley Act (SOX). D. The Employee Retirement Income Security Act (ERISA). Answer: A. The Fair Credit Reporting Act (FCRI). Explanation: FCRI restricts employers from accessing personal credit records without written consent. If an employer mandates financial disclosures, it could face regulatory penalties and employee lawsuits. Why not B? FLA? FLA deals with family leave, not financial privacy. Why not C? SOX? SOX governs corporate financial reporting, not employee privacy. Why not D? ERISA? ERISA concerns retirement plans, not employment screening. Question 24. During a critical moment when precise judgment is necessary, an autonomous vehicle manufacturer discovers that its AI system is unable to detect pedestrians in certain lighting conditions. Regulators demand immediate changes. What law might apply? A. The National Traffic and Motor Vehicle Safety Act. B. The Americans with Disabilities Act (ADA). C. The Fair Credit Reporting Act (FCRA). D. The Consumer Credit Protection Act (CPA). Answer: A. The National Traffic and Motor Vehicle Safety Act. Explanation: this law gives the National Highway Traffic Safety Administration (NHTSA) authority to regulate vehicle safety. If an AI-driven car has a major safety defect, the manufacturer must issue recalls or face legal penalties. Why not B? ADA? The ADA governs disability rights, not vehicle safety. Why not C? FCRA? A cry concerns credit reporting, not vehicle regulations. Why not D? EECPA governs consumer privacy, not vehicle safety. Question 25. When implementing new protocols in a shared environment, a hospital decides to share patient data with a third-party marketing firm to analyze trends. A whistleblower claims this is illegal. What law applies? A. The Health Insurance Portability and Accountability Act, HIPAA. B. The False Claims Act, FCA. C. The Stark Law. D. The Patient Self-Determination Act, PCD. Answer A. The Health Insurance Portability and Accountability Act, HIPAA. Explanation. HIPAA prohibits selling or sharing patient data without explicit consent. Violations can result in multi-million-dollar fines. Question 26. During a critical moment when precise judgment is necessary, an air traffic controller notices two planes on a collision course. To prevent disaster, they override standard procedures and instruct one pilot to deviate from an assigned flight path. Later, an investigation questions this decision. What legal or regulatory framework applies? A. The Federal Aviation Regulations, FARs. B. The Air Carrier Access Act, ACAR. C. The Aviation Safety Reporting System, ASAS. D. The Transportation Security Administration, SAR Act. Answer A. The Federal Aviation Regulations, FARs. Explanation. The FARs provide the legal framework for aviation safety and establish protocols for emergency decision-making by air traffic controllers and pilots. Under FAR Part 91.3, the pilot in command has final authority over the aircraft's operation, but controllers must also act swiftly to avoid imminent danger. Why not B. ACAR? The ACAR focuses on passenger rights and accessibility rather than air traffic control decisions. Why not C. ASAS? The ASAS is a confidential incident reporting system, not a regulatory framework. Why not D. SAR Act? The SAR Act governs security protocols, not emergency flight decisions. Question 27. When implementing new protocols in a shared environment, a multinational company introduces mandatory biometric login systems for all employees. Some employees raise concerns about potential data breaches and privacy violations. Which legal framework applies? A. The General Data Protection Regulation, GDR. B. The Electronic Communications Privacy Act, ECPA. C. The Stored Communications Act, SCA. D. The Occupational Safety and Health Act, OSHA. Answer A. The General Data Protection Regulation, EDPR. Explanation. DDR strictly regulates biometric data as sensitive personal information. If an employer collects biometric data without proper consent or security measures, it can face severe fines and lawsuits. Why not B. ECPA? The ECPA governs electronic communications monitoring, not biometric data. Why not C. SCA? The SCA regulates stored electronic messages, not employee biometrics. Why not D. OSHA? OSHA focuses on workplace safety, not data privacy. Question 28. In a situation where formal requirements conflict with patient autonomy, a patient with a terminal illness refuses further treatment. However, their family insists that the hospital continue life support. Which legal principle determines the hospital's course of action? A. The Right to Try Act. B. The Patient Self-Determination Act, ECDA. C. The Health Insurance Portability and Accountability Act, HIPAA. D. The Controlled Substances Act, CSA. Answer B. The Patient Self-Determination Act, PCDA. Explanation. The PCDA gives patients the right to refuse medical treatment even if it leads to death. Unless a patient is mentally incapacitated, their decision overrides family wishes. Why no Right to Try Act? This law allows access to experimental treatments, not refusal of care. Why not C. HIPAA? HIPAA governs privacy laws, not treatment refusal. Why not D. CSA? The CSA regulates controlled medications, not end-of-life decisions. Question 29. During a major transformation where existing methods must adapt to new policies, a city government implements an AI-driven facial recognition system to monitor public spaces. Civil rights groups challenge this on privacy grounds. Which legal issue applies? A. The Fourth Amendment of the U.S. Constitution. B. The Electronic Signatures in Global and National Commerce Act, SIN. C. The Fair Credit Reporting Act of CRA. D. The Computer Fraud and Abuse Act, CFA. Answer A. The Fourth Amendment of the U.S. Constitution. Explanation. The Fourth Amendment protects individuals from unreasonable searches by the government. Courts may determine that constant AI surveillance without a warrant violates constitutional rights. Why not B. SIN? SI deals with electronic contracts, not privacy. Why not C. FCRO? FCRO governs credit data, not surveillance. Why not D. CIFA? CIFA addresses computer hacking, not facial recognition. Question 30. When implementing new protocols in a shared environment, a hospital begins sharing patient records with a third-party tech firm to develop predictive analytics for disease outbreaks. A lawsuit claims this violates medical privacy laws. Which law applies? A. The Health Insurance Portability and Accountability Act, HIPAA. B. The Sherman Antitrust Act. C. The Federal Trade Commission Act, FDA. D. The Genetic Information Non-Discrimination Act, GINA. Answer A. The Health Insurance Portability and Accountability Act, HIPAA. Explanation. HIPAA prohibits unauthorized sharing of patient health records. Hospitals must obtain explicit patient consent before sharing medical data with third parties.